The Romans had this very strong system of classification. They put something into this category, into that category. What the Romans believed is that what you did is you did the hard categories. You're a social guest on the one hand, or you're a business guest, and then we give you legal rules to figure out what the risk of liability are. And they're the exact same principles you'd use in other areas, where it's for mutual benefit, there's a higher standard of care. Where it's gratuitous, the party who is doing the favor gets the benefit of the doubt on these cases, and so on down the line. When you get to modern law, the common law, I think, goes wrong today, because what we do is we do this stuff as a reasonableness standard, but there's a subtle change in the way in which the rules work. The Roman stuff was the categories had to be right, and the difficulties came in dealing with marginal cases. What the modern law tends to do is to say, look, we don't trust these categories. We're going to have sliding scales of reasonableness that go from one end to another, and we're not going to have these hard lines. So what happens is, in this system with the continuity, you don't have to worry about the borderline cases because there are no borders. But the greater failing is this. If, in fact, human conduct is highly irregular, so that the probability of getting yourself into one of these marginal cases is relatively low, the better business judgment is to give you clear rules that cover 98% of the cases and worry about the 2% of the cases later, rather than to jeopardize the 98% of the cases because you're not quite really sure what's going to be required, and leave it to everybody else's imagination. And so this then becomes, in modern terms, the rule v. standards debate. And there may be circumstances where standards are certainly going to be appropriate, but by and large, they're not going to be in everyday relationships. And why is that? Because when people organize their own lives in dealing with small transactions, they're really not particularly congenial with a type of situation in which they don't know where they stand. And so if you're trying to figure out how you give people instructions to resolve disputes outside the framework of a legal system, the category approach and the normal standards are there. The genius is to get the right rules. And the Romans did that because they understood that gratuitous promises were a really important class of cases. There may not be executory enforcement, but there are all sorts of things that take place once the transaction is started, before the thing is completely unwound.